Start. The amendment of Section 173A of the UP Municipalities Act has not made any difference, as the amount due against the petitioners is not a tax. Under the provisions of the UP Zamindari Abolition and Land Reforms Act, an amount other than land revenue can be recovered as arrears of land revenue only if it is made recoverable as such under any statutory provisional in case the amount due is not land revenue or is not made recoverable as arrears of land revenue under the statutory provisions. The said amount cannot be recovered as arrears of land revenue. The amount due from the petitioners not being an amount of arrears of tax. The recovery of the said amount cannot be made as arrears of land revenue by invoking the provisions of Section 173A of the Municipalities Act and Section 21 of the UP Town Area Act. Section 293 of the Municipalities Act provides that municipality may charge fee to be fixed by bylaw or public action or by agreement for the use or occupation otherwise that under a lease of any immovable property vested or entrusted to the management of the municipality, including any public street or place of which it allows the use and occupation, whether by allowing a projection thereon or otherwise. The petitioners were required to pay a fixed sum under the contracts. The contracted amount is not Tehbazari. Tehbazari dues were payable by the shopkeepers for the use of land. Therefore, the Tehbazari dues cannot be equated with rent or other dues in respect of the property vested in a local authority, recoverable as arrears of land revenue under the provisions of Section 225 of the UP Zamindari Abolition and Land Reforms Act. Under Section 293 of the UP Municipalities Act, the municipality may charge fees or use otherwise than under a lease of municipal property. The amount due is not fees but contract money, therefore cannot be recovered under the provisions of Section 293 of the Act. Moreover, the recovery of fee for use as contemplated under Section 293 of the Act cannot be made as arrears of land revenue. The recovery of the arrears of fee under the said provision is to be made under Chapter 6 of the Act by distress or sale of movable property. The question whether the amount due towards the contract for realization of Tehbazari dues can be recovered as arrears of land revenue came up for consideration before this court in the case of Mumtaz Ali versus Divisional Magistrate and others 1970 AWC. It was held that there is no provision under the UP Municipalities Act or UP Town Area Act authorizing the respondents to realize Theka money as arrears of land revenue. As such, the said amount cannot be recovered in the said manner. In view of these facts, the respondents have no authority to recover the amount of Theka money due against the petitioners as arrears of land revenue. The question that fell for consideration again was whether a sum of money due to Nagar Palika Parishad from a person under a contract for realization of Tehbazari can be realized as arrears of land revenue under Section 173A of the Act of 1916. Answering the question in the negative, it was held by their lordships thus. In view of the aforesaid provisions of the learned counsel for the petitioners submits that it is clear that only taxes which are due to the municipalities can be recovered as arrears of land revenue, and no other sum can be recovered as arrears of land revenue. The petitioner has placed reliance upon a division bench judgment of this court reported in 2006 and others, and reliance has been placed upon paras 10, 12 to 14 and paras 15 and 17 of the said judgment, and has submitted that the division bench of this court has held that amount due towards the contract for realization of Tehbazari cannot be recovered as arrears of land revenue, and there is no provision under the Municipalities Act or UP Town Area Act authorizing the respondents to realize theka money as arrears of land revenue. As such, the said amount cannot be recovered in the said manner, and has held that in view of the aforesaid act, the respondents have no authority to recover the amount due to the petitioner as arrears of land revenue. We have considered the submission made on behalf of the petitioner and the respondents. We are in full agreement with the judgment relied upon by the counsel for the petitioner, as there is no factual dispute in the present writ petition. The only question was to be decided whether the amount due against the petitioner can be recovered as arrears of land revenue or not. As, in view of the division bench judgment of this court, which is fully applicable to the present case, the Tehbazari amount due against the petitioner cannot be recovered as arrears of land revenue. As such, without inviting the counter affidavit with the consent of the parties, the writ petition is being disposed of. Section 291 and 292 of the Act of 1916 find place under Chapter 8 of the Act of 1916 entitled Other Powers and Penalties. Section 291 to 294 are placed under the heading Rent and Charges. These read: recovery of rent on land where any sum is due on account of rent from a person to a municipality in respect of land vested in or entrusted to the management of the municipality. The municipality may apply to the collector to recover any arrear of such rent as if it were an arrear of land revenue.